Good day to you and welcome to another Paddocks Club video tutorial. Today I want to talk to you about why you should revise your Homeowners Association's Memorandum of Incorporation. The Companies Act No. 71 of 2008 has been in operation since the 1st of May 2011. It provided for a 2-year period of grace for existing companies to update their governance documents, which were previously known as their Memorandum and Articles of Association, and which same documents are now referred to as their Memorandum of Incorporation. During this period, most of the provisions of the pre-existing articles continued to be valid, even if they weren't in accordance with the requirements of the new Act. But the grace period terminated on the 30th of April 2013, and now any provision in a company's governance documents that is contrary to the Act is invalid and therefore misleading. While the directors of a non-profit homeowners association company that has not yet updated its governance documents are not legally obliged to initiate that process, they should really do so. It makes a lot of sense for them to do so. In the first place, it makes no sense to run any organization on the basis of a set of documents that don't reflect the requirements of the law or, in fact, contain misleading statements. Another very good reason is that in terms of Section 76 of that Act, a company director is obliged to exercise a reasonable degree of care, skill and diligence in performing his or her functions. So I think one can accept that a company director must make sure that they are working off the correct script. The Act provides a precedent of the MOI for a non-profit HOA company with members, and that is COR 15-1E. As a company's MOI cannot contain any provision that is in conflict with the Act, most of the provisions in this prescribed form are just statements as to whether the various provisions of the Act that can be altered in the MOI have in fact been altered or not. The prescribed form caters for details of any company-specific arrangement or provision to be included in a set of schedules, so a reader has to flip back and forth between the various parts of the document, the substance in the body of the document and the schedules, to understand its provisions. It's in those schedules that you must, for example, put conduct rules, architectural restraints and conditions, and fining provisions if you have such things. The form has also been criticised because it doesn't include any statements of the unalterable provisions of the Act that are relevant to the management of the company. This means that in order to see all the provisions that apply to the management and administration of the company, the reader must look not only at all parts of the MOI, but also at a copy of the Companies Act. And the reader must understand when reference to the Act is required to supplement the provisions of the MOI. So a relatively high degree of legal expertise is required to use this type of document properly. But the company isn't obliged to use the prescribed form as the basis of its replacement MOI. The directors can arrange for a unique form of MOI to be drafted. Apart from the special provisions for the particular HOA, this doesn't need to be a highly complex or lengthy document, but a decision will still have to be made as to whether the MOI will include statements of the relevant unalterable provisions of the Act so that it can be read as a standalone guide to HOA governance, or whether it will be a much shorter document designed to be read in conjunction with the Act itself. If you require any assistance in bringing your HOAs more into line with the requirements of the Companies Act, please contact us at consulting@paddocks.co.za for a no-obligation free quotation.